Hello and welcome to Delhi Law Firm. Today we bring you a very important case explained in a simple and people-friendly way. This judgment was delivered by the Rajasthan High Court, Jaipur Bench, and it directly impacts all those couples whose marriage took place in India but one of the partners is a foreign national. Many people believe that if the partner is not an Indian citizen, the marriage cannot be registered, and due to this misunderstanding, many genuine couples suffer for years. This judgment has permanently removed that confusion. It sets a clear precedent regarding law, the constitution, the right to equality, and the entire process of marriage registration.
Absolutely. In this case, the petitioner couple consisted of an Indian wife and a Belgian husband. They performed a Hindu marriage on 18 January 2010 at Arya Samaj, Ajmer. They even had a marriage certificate, but when they went to register their marriage, the registrar of Hindu marriage Ajmer orally refused, saying, "Your marriage cannot be registered because the husband is not an Indian citizen." No inquiry, no written reasons, no legal justification. Against this arbitrary action, the couple approached the Rajasthan High Court, and after 14 long years, in 2023, a historic judgment was delivered.
Exactly. The court raised a fundamental question. Can marriage registration be denied solely because one person is not an Indian citizen? And the High Court clearly said, no, such refusal is against the law, because Sections 5 and 7 of the Hindu Marriage Act 1955 do not say that both parties must be Indian citizens for marriage or for its registration. Marriage registration is only a proof for convenience. It has nothing to do with the validity of the marriage itself.
Yes, here's another important point. Section 1 subclause 2 of the Hindu Marriage Act says that the act also applies to Hindus living outside India. So if an NRI or a foreign Hindu comes to India and marries according to Hindu rites, the marriage is completely valid. Similarly, Section 8, which deals with registration, never says that citizenship is mandatory. So the registrar's reason, the husband is a foreigner, therefore registration cannot be done, is a direct violation of Article 14, the right to equality.
The court also relied on several important judgments of the Delhi High Court, such as Bhumika Mohan Jaisingh Hani, Aryan Far, and Arushi Mehra, where the High Court clearly held that, whether under the Special Marriage Act or the Hindu Marriage Act, citizenship is not a barrier for marriage registration. In fact, the Delhi High Court even ordered the government to modify its software and portals so that foreign nationals can apply online.
The Rajasthan High Court also stated that the officer's reasoning was completely illegal because the application form does not say foreign nationals cannot register. The Hindu Marriage Act does not say this. The Special Marriage Act does not say this. The Constitution does not say this. So refusing registration on this basis is a misinterpretation of law.
The court then analyzed Article 14, Equality before law, and clarified that many fundamental rights apply to foreign nationals as well. For example, Article 14, Equality, Article 21, Right to Life, Article 25, Freedom of Religion. Foreign nationals are entitled to these rights, and denying marriage registration solely because someone is not Indian is discriminatory.
Another crucial point the court made was this. If a Hindu marriage has been properly performed and evidence exists, the registrar is legally bound to register it. Whether under the Hindu Marriage Act or the Special Marriage Act, there is no rule that says Indian citizenship is mandatory. So refusing registration is not only unlawful but also arbitrary.
Now let's discuss the final directions of the court, which act as guidelines for all states. The court ordered that the registrar must immediately register the couple's marriage subject to proof. The Rajasthan government must amend its marriage registration guidelines. The e-portal and software must remove the Indian citizen mandatory restriction. No foreign national who has legally married in India should be denied registration. This order has become an important guiding principle for marriage registration authorities across India.
This judgment is not just a victory for one couple, it is relief for thousands of couples across India, including NRIs, OCIs, and foreign Hindus who struggle for marriage registration. The court clearly stated, refusing registration solely on the basis of citizenship is unconstitutional. This decision also helps reduce complications in international marriages, inter-country marriages, and immigration processes.
Let's simplify this. If your marriage took place in India according to Hindu rites, whether your spouse is from Belgium, America, Canada, UK, Europe, or anywhere else, your marriage is fully valid in India, and you have the legal right to get it registered. No authority can refuse your registration, not on the basis of citizenship, not on any circular, not due to any misunderstanding.
Many people also assume that if the partner is a foreigner, they must go through the Special Marriage Act. But the court clarified, if two Hindus marry according to Hindu rites, they can register under the Hindu Marriage Act, even if one is a foreigner. There is no need to re-solemnize the marriage or undergo the Special Marriage Act's notice period. This is especially helpful for those needing marriage certificate for visa, spouse visa, PR, or citizenship applications.
Now an important practical question. Is the Arya Samaj certificate valid? In this case, the couple had an Arya Samaj certificate. The court said, if the marriage is genuine, rites were performed and evidence exists, such as Saptapadi, then the Arya Samaj certificate is a valid piece of evidence. The registrar may ask for additional proof, photos, videos, witnesses, but cannot refuse registration.
So, if any officer refuses, the couple has two legal rights: ask for written reasons and file a writ petition in the High Court. And as seen in this case, the court will intervene quickly because this concerns fundamental rights.
Now the social importance. India witnesses thousands of cross-border marriages every year. For such couples, the marriage certificate is essential. If registration is denied, then visa cannot be issued, spouse visa gets rejected, immigration cases get stuck, even the child's birth certificate becomes complicated. So this judgment aligns perfectly with modern societal needs.
And that is why the court ordered the Rajasthan government to immediately remove the Indian citizen mandatory line from the software and application forms, because the law does not impose such a condition. In today's digital era, software errors create the biggest problems. The court took this very seriously.
Now here are practical guidelines for couples where one partner is a foreigner and they want to register their marriage. Arya Samaj or Pandit issued marriage certificate, marriage photos, witness ID proof, passport and visa copies of both spouses, proof of date and place of marriage. With these documents, registration is your legal right.
If any officer tells you, we do not register marriages of foreign nationals, you can simply show this judgment. The registrar is legally bound to register the marriage. This judgment is a precedent for the whole country.
So friends, this was the very important decision of the Rajasthan High Court, a decision delivered 14 years after the marriage, but one that cleared the way for thousands of couples. This judgment shows that law looks at the validity of the marriage, not citizenship. Every valid marriage in India has the right to be registered, regardless of nationality.
If you also face such issues, marriage registration problems, foreign partner marriage issues, Special Marriage Act complications, visa or embassy requiring a marriage certificate, or arbitrary refusal by officers, our legal experts are here to help you.
For any marriage-related legal matter, contact us. We handle cases all across India. Visit our website www.dellylawfirm.news. Thank you.